Well, my clock says 7:30. My name's Alan Miller, one of the members and the co-founders of Together Declaration and Together Association. Welcome everyone this evening. It's really exciting to have you here. We're also streaming live on Facebook, so hello to everyone that's there. And then we'll also be posting subsequently on YouTube and on all our socials. Just to say, we have a series. This is the first in a series that Together is organising panel debates on a number of bills that are of question. And this first one tonight on the Human Rights Act and any amendment or not, and the Bill of Rights is a really crucial discussion and debate. We've had a lot of people come back to us saying that, you know, this is really important, make sure we get the consultation in. And in line with our 7 pillars, open debate is the key part of that, having free speech and a discussion, often when things are confusing and perhaps when people disagree about things. And so we can drill down and get clarity. It's also important for any campaigning work that anyone does and lobbying to make sure we're all clear of the issues and what they mean. As we saw in the announcement that the Coronavirus Act looked like it would be going, but 2 to 4 of the elements within it would be continued. One in the Public Health Act, which, as we remember, was used to actually lock us down, not the Coronavirus Act. One that would go into the Police Crime and Sentencing Bill, and 2 others, and potentially that they could be brought back again. We know that some of these ongoing discussions about bills and acts are very important. We also have a session coming up next week on the online safety bill. The week after that, we're doing it on the Police Crime and Sentencing Bill. And then we're finishing up the series on digital ID, which we now know that vaccine passports have gone, but digital ID looks like it's going to be required for work and to rent, and also the relationship between digital ID and central bank digital currencies. All of these things we might find that in this discussion have some links to one another and are interrelated, and we might find they don't. But I'm very pleased to say that we've got 2 really great speakers this evening who are going to shed light in different ways on what we should be looking at. Firstly, we've got Clare Harrison, who writes regularly on awakenedworld.co.uk. She's a lawyer as well. And I really would encourage people to have a look at that site. I read a really brilliant piece by Clare on the question of social contract, where she quotes many people from Locke and Kant and others in the context of how our rights come about, what they mean, and why they need to be maintained. And I actually think that in such a fast-paced, moving set of circumstances, it's always good, it's really important to look back at how rights got conceived, got fought for, political rights, and what they mean. And then we've also got Luke Gittos. And Luke Gittos wrote a book in 2019 saying human rights and illusory freedom, why we need to repeal the Human Rights Act. And he will say why he thinks that, and in the context of political rights versus human rights. Just to say, I'm going to shut up in a minute, which will relieve everyone. But basically, the format will take the form that the 2 speakers will speak for up to about 10 minutes. We're going to have Claire first and then Luke. I'm then going to ask a few questions based on some of the things they've said and pose a couple of questions that have come up that people have sent to us to start and kick off the debate. Then we're going to go out to you guys on Zoom and get questions in rounds, which will go back and forth. And I think looking at the numbers, we should be able to get most people to speak and contribute. I would ask you, it doesn't have to be a straight question, but to try and keep the questions as brief as possible, or the contributions, so we can get round to everyone, and to try and keep it on topic, please. The last thing I will say is this: we believe in complete free speech and open debate, but we're also grown up, and we think the civil engagement's really important. No matter how outraged you might get about what someone says, let's engage civilly. Let's do what perhaps the elected leaders have not been able to do, and have a robust, difficult, complicated, grown-up adult conversation, and come out the other end at least as friends, even if we disagree on some of the content of some of the points. So without further ado, I am going to ask Claire to start and kick off. And please remember to keep yourselves on mute whilst people are speaking. Thanks very much.
Thank you, Alan. Hello, everybody. I just want to say thank you to Together for inviting me on. I've actually written down what I'm going to say, and I'm going to go back to a brief bit of history, which I hope will help people to understand a little bit more about human rights. So I hope you don't mind that I'm going to read from what I've prepared. So I might not be looking straight at you all the time. So to start with, I just want to start with what I've written, and that is that the international human rights movement was strengthened with the adoption of the Universal Declaration of Human Rights, which we commonly call the UDHR, on the 10th of December 1948. That was drafted as a common standard of achievement for all peoples and nations, and it spelt out basic civil, political, economic, social, and cultural rights that all human beings should enjoy. Members of the Council of Europe used that declaration to draw up a treaty called the European Convention on Human Rights, ECHR, the purpose of which was to secure basic rights for their own citizens and for other nationalities within their borders. The convention was signed in Rome in 1950, so over 70 years ago, and it was ratified by the UK in 1951, came into force in 1953. The important distinction between the ECHR and the UDHR is that the ECHR contains rights which can be relied on in a court of law. So since then, there's been a series of international human rights treaties and other instruments adopted which have conferred legal form on what we call inherent human rights. There's been a body of international human rights jurisprudence developed. Some countries have also adopted constitutions and other laws which formally protect basic human rights. And for instance, in the UK, we currently have the Human Rights Act 1998, which I will call the HRA as I read. So the HRA took 16 of the fundamental rights from the ECHR and basically pulled them down into our domestic law. I won't go through those rights, but I will share this document with everybody in due course. So whilst domestically we have the HRA, international human rights laws also lay down obligations which countries are bound to respect. And by becoming parties to international treaties, countries therefore assume obligations and duties under international law to respect, protect, and fulfill human rights. So even though the government has indicated that it wishes to reform the HRA and replace it with a Bill of Rights, it has confirmed that the UK will not leave the ECHR. So that's important to know. What I want to state here, and what I think is really essential that everybody grasps, is that human rights belong to everyone. Then the rights set out in the HRA and the ECHR are not gifts from the government or rewards that you earn. They are yours by right, and they can only be taken away in qualified situations, some of them, not all of them. This was confirmed by Lady Hale, the former president of the Supreme Court, in the famous Cheshire West case. In addition, the Human Rights Act and the ECHR are in fact the minimum standards of human rights which should be met by the state and others, not the highest benchmark, so don't make that mistake. In a nutshell, the state going about its business, along with others, have an obligation to respect and uphold human rights, and the Human Rights Act, our domestic courts and the European Court of Human Rights are there supposedly to provide a checks and balance system of making sure the state and others at least meet minimum standards. So that's a little bit of history for you. As we know, the UK government is in seeking to reform the HRA, wishes to adopt a new Bill of Rights. On the 14th of December 2021, the government published the independent report on the Human Rights Act, and this was written by a panel of independent Human Rights Act review members. That panel, for short, I'm going to call it the IHR or the panel. Okay, it might be easier. They also published its own consultation called Human Rights Act Reform, a Modern Bill of Rights. I would say this has caused widespread concern and frustration across much of civil society in the UK, largely because it appears the government is ignoring its own independent panel that looked into the HRA, rather than reflecting on the evidence provided by the people that were on the panel, the thousands that have contributed to it, the organisations that contributed to it. The Ministry of Justice instead released a consultation which proposes not amending the HRA, which is what the review was tasked with looking into, but instead replacing it with a Bill of Rights. So in some ways, you could argue the government has already misled us by stating that human rights would be amended, when what they really mean is that they're going to be replaced by something different, the content of which no doubt they would decide, not us. I believe this should concern us all. The government's consultation looked at 5 key areas of human rights. I would encourage everyone to go to the website of the British Institute of Human Rights to view these key areas and to see what the BIHR have to say about the same. They've done an awful lot of work, and I know that some of the panel will be speaking about the BIHR later. So I want to let you know that the Independent Human Rights Review panel received over 150 responses. They ran a number of roundtable meetings to hear directly from different groups of people when discussing the reforms. Their full report is 580 pages. The executive summary is 28 pages. I've put both in this document, which I will share. In my opinion, the government intends to largely ignore the recommendations of the Independent Human Rights Review panel. These were independent experts that the government put together themselves. They're also probably going to ignore the public consultation because it suits them to, and this is just my opinion. The government appears to be basing the case for reform on the same arguments that dear old Dominic Raab put forward in his 2009 book called The Assault on Liberty, available on Amazon if you would like to purchase it. This might not be so bad if we had faith that Dominic Raab and indeed the sitting government actually had the best interests of the people in this country at heart. I would question if they do, especially given the last 2 years. So I feel that the overarching desire of the government's proposed reforms is in fact to rewrite the law, which sets rules on the power of the state, so them, provides minimum standards of human rights for how people should be treated when interacting with the same, and which provides domestic legal remedy when minimum standards of human rights are not met. So I should make clear that the Tories wishing to reform the Human Rights Act is not a new thing. In 2006, David Cameron argued for a Bill of Rights to replace the Human Rights Act. It was put on the back burner, reared its head again in the Tory party manifesto in 2015, was again put on hold in 2016. However, just because the reforms were placed on hold then does not mean that they will be delayed now. The current reforms mooted are, in my opinion, constitutionally significant, and they need to be viewed not in isolation, but in the context of what has happened over the last 2 years, and also in light of other proposed legislative changes, the push for central bank digital currency, a policy paper for which was published by the G7 on the 14th of October 21, supported by HM Treasury and Rishi Sunak, calls by the Bank of England for ministers to decide whether that central bank digital currency should be programmable, ultimately giving the issuer control over how it is spent by the recipient, and the social contract concept, which Alan mentioned, and whether the UK government are upholding their end of the same. There are currently many HRA reform proposals that I am concerned about. I particularly have focused on 6 as key highlights. If we get time, we can go through them. There are other proposals that are likely worrisome, but I have not even finished looking at the full report documentation yet because it's so weighty and lengthy. I want you to know I'm not an expert on human rights. I work in succession law. Please do know that in this case, I'm just like all of you listening in, a concerned citizen seeking to understand what the reforms will mean in practice for the average person. I would like to make clear at this stage that I personally do not believe that human rights are upheld as fiercely as they could be. So I do recognise that we already have a problem with access to justice in this area. I'm also of the opinion that in the last 2 years, there have been abuses of human rights and a failure to protect them, with no one having been held accountable for the same yet. However, these problems seem to me to stem from the system as a whole failing or not working as well as it should, along with what I call the breaking of the social contract that I mentioned above, rather than legislation and the European Court of Human Rights itself being out of touch or out of date. I do not accept that we should simply shrug our shoulders about the proposed reforms as a result of the difficulties that we are facing and have faced. And I feel that if we do nothing about the proposals, we could very well end up in a worse scenario than we already are. So I've mentioned about the breaking of the social contract. This isn't a topic to be discussed at length in this debate, but it warrants a brief explanation. In short, the social contract in political philosophy is an actual or hypothetical compact or agreement between the ruled or between the ruled and their rulers, defining the rights and duties of each. The social contract concept suggests we all have a hand in deciding what rules we should follow, and that we all have a hand in electing those that will ensure those rules are upheld for the benefit of all. However, I feel that certainly now more than ever, this does not seem to be the case. And to me, it is clear that it is not just those we have elected to govern us under social contract concepts that have a hand in telling us what is for our own good. There are think tanks, corporations, independent organisations and government departments, such as the Cabinet Office, that have a hand in making policy and writing laws that we are all supposed to adhere to. These institutions rarely consult us or ask us if laws and policies are in fact for our own good or whether we even agree with them. They arbitrarily decide for us, but nevertheless, we are expected to keep to our side of the social contract wrapped up in them, continue to pay taxes and behave ourselves. Whilst the government fails, in many cases, to keep to its side of the bargain by declining to uphold laws that protect human rights and equality, failing to utilise its resources to make the public's life better, and by failing to offer recourse to justice when the state has failed in its social contract promises. It is in this context that I believe that we need to review the proposed human rights reforms. Thank you.
Thank you, Claire. We can do a little clap for everyone after Luke speaks as well. Thank you very much. A lot to muster there. It's a lot for us all to consider, both the historic and the contemporary questions. So over to you now, Luke. Thank you.
So, as Claire suggested, the proposed reforms to the Human Rights Act have been on the Conservative Party policy table for a very long time. Alan mentioned that I wrote a book in 2019 about this issue, and even then it's been on their policy table for a very long time. And I think what remains true today, as it was then back in 2019, is that both sides of the political spectrum in this debate really exaggerate the relevance of these reforms. I think on the left, there is a major problem that people believe that the Human Rights Act is uniquely capable of protecting the vulnerable. And I think it's proven over its life that it's almost entirely incapable of having significant political impact on the issues it targets. Similarly, on the right, I think that there is a tendency to massively overestimate the impact of human rights law, statute law and jurisprudence. I'm going to use some law words, so I'm sorry if I'm boring enough to actually know what they mean, but if you want to know what they mean, we can talk about it in the questions. But human rights statute law, i.e. the Human Rights Act, and human rights jurisprudence, i.e. the decisions of judges related to human rights. I think on the right, the tendency is to massively inflate the impact of both those things when it comes to real life cases. When you look at the impact that the Act has had on our courts, in some respects, it's been very influential, but when you look at actual decided cases, the courts are very, very good at finding their way through the provisions of the Human Rights Act and are very good at limiting its impact on individual freedom. So the idea, when you look at a lot of the statistics quoted by those on the right about how this act prevents the deportation of murderers and lets paedophiles out of prison early, a lot of it is completely inflated and ridiculous. So I think both sides of this debate get it wrong. But I think the key problem that we face is with the issue I mentioned with respect to the left, this kind of over-exaggeration of the ability of the Human Rights Act to protect our most fundamental freedoms. And I think, if anything, the pandemic has made that absolutely clear. Because although there were a number of prominent human rights lawyers involved in the debate around the pandemic, actual human rights law was largely absent from the scene. It's quite notable that the various judicial reviews, the legal cases that were brought to challenge any aspect of the pandemic, which was the greatest incursion on our civil liberty in peacetime, came to absolutely nothing. And I think what that illustrated is that human rights law has always been a system that allows for the erosion of liberty. And I think it's always been that way. It's always been a system that has been designed to, in some ways, facilitate the erosion of freedom rather than protect it. And I think I'll come on to talk about the actual reforms in a moment, but if we go back to New Labour, the origins of this act, and Claire's done a very good job of summarising the journey that got us there, we could talk a little bit more about the history of the European Convention, and if you like. But really, that moment when this act is introduced in 1998, it comes in as a result of New Labour, and principally a policy turn within New Labour, which I would argue was twofold. Firstly, New Labour thought it was very important to focus on constitutional reform. They saw this as a very big part of their policy agenda. Tony Blair and his sort of loyally ilk, the people around him, a lot of whom came from the English bar, a lot of them were barristers. A lot of them were obsessed with constitutional reform, saw it as a big part of their policy platform. And I think part of that was their veneration of the ability of judges and other sort of technically minded people to solve a lot of societal problems. So what you see with the Human Rights Act is part of a package of constitutional reforms which placed judges and the judiciary in a greater position in public life, provided greater power for the judiciary to make politically significant decisions. Part of that can be seen, part of the veneration of judges is seen in the establishment of the Supreme Court, so the separation out of the Supreme Court from what was the House of Lords into its own chamber across the road in Westminster. But arguably that was a superficial change. The real indicator that of New Labour's veneration of the judiciary was the creation of the Human Rights Act and the introduction of the European Convention of Human Rights into English law. Again, that all sounds very, very technical. So what do I mean by that? Well, I think New Labour were a government who believed in judges and technocrats in their ability to make society better, broadly. And the Human Rights Act was a way in which judges could decide the proper limits of important political freedoms. So since its inception in the European Convention, and then it being brought into law under the Human Rights Act in the United Kingdom, the point of human rights law is to give judges the power to shape our freedoms, our most important freedoms. And actually, when you look at the sort of legal definition of free speech or the right to protest or the right to life under the convention, it's always deeply, deeply qualified. In fact, when you read if you look at the European Convention on Human Rights, what they're actually doing is defining the circumstances in which a government can legitimately limit these freedoms rather than seeking to protect them. If you look at Article 10, for example, which purports to protect freedom of expression, that article says you have your freedom of expression subject to these qualifications. And there's a very, very long list of qualifications. So it was always a way in which the judiciary could effectively manage the limits of free expression, freedom to protest, etc. And of course, at the same time, under New Labour, we saw the introduction of very, very draconian legislation in the form of the Regulation of Investigatory Powers Act, RIPA, arguably the most extensive set of new powers for surveillance, for significant incursions into privacy that we'd ever seen. RIPA was a very, very significant piece of legislation when it came to incurring on our freedom. And then New Labour, of course, created reams and reams of legislation which allowed for official intervention into people's lives. Look at antisocial behaviour legislation, something like 3,000 new criminal offences created under New Labour. So what we have is the Human Rights Act being passed at the same time as a whole series of very, very draconian pieces of legislation, which should illustrate that really the Human Rights Act exists in what I would call a sort of legal bubble. It really does protect a model of freedom, which is only really of value to a very, very small pool of people and in a very narrow set of circumstances. So that would be my broad argument, is that really, and it stems from my original point, that both sides are exaggerating the potential impact of these reforms. Both tend to see the Human Rights Act as either a vital protection for the vulnerable on the one side, or on the other side, a sort of significant incursion on judicial or legislative sovereignty. And it's none of those things. So I wanted to say a little bit about the vaccine mandate issue and the pandemic, and make the point really that the true threat to liberty in today's society, I think, is legislation. And that's the principal point that both sides of this debate tend to miss. As we saw in the pandemic, our legal freedoms, our so-called hallowed freedoms, can be wiped out with the stroke of a minister's pen if we allow it to be. And that is why it was so vital for Together and others to lobby to create a political space for activism, because it's through activism that we actually argue for the limits of the law. And it's the limits of the law that allow for civil liberty. Our civil liberties are the space at which the law ends. And I think the fundamental ideological mistake that's been made by the proponents of human rights is that they imagine that law can cover everything. It can permeate everywhere. It can create this free society in which the courts mediate the relationship between the state and the individual so effectively that we no longer need to worry about those spaces in which law is absent. And I think that's the big challenge for our political culture today, which is to argue that the law should have its limits, that there should be some things which the state should not do. There are some areas of life that the state should not intrude upon, whether that be through human rights and the decisions associated through human rights, or through any other form of legislation or court. The fact is that the law is a blunt instrument, and it is the way in which the state impinges on our freedom. And I think in the 21st century, we need to reclaim the idea of political freedom by arguing for a model of political rights, which has nothing to do with human rights or the legacy of the human rights legislation or the human rights tribunals in Europe. So just very briefly then on the proposed reforms, if we are looking for that kind of culture where law is limited in its role and in its impact on our lives, then these reforms don't go nearly far enough. In fact, they change very little, I would argue. We can talk about specific proposals, but the reform that this government is talking about is very, very small. As was suggested, there's no proposal that we will actually leave the European Court of Human Rights. European jurisprudence will retain its influence, although the influence will apparently be diluted, but it will still retain its influence on UK courts. There are some reasons why this reform might well be a step in the right direction, in that it argues that we have a strong history of constitutional rights in this country, which I would argue is perfectly true, reference Locke, Hobbes and others. But these reforms maintain the structure of human rights law, and they maintain, a constitutional Bill of Rights, the kind of thing that they're talking about, would sort of retain the faith in the legal system to protect our freedom. And I think if we're going to argue for a meaningful idea of freedom in the 21st century. We should start by looking beyond the law, beyond the courts, and to a model of freedom which is more rooted in politics and setting a strict limit on the law rather than expanding it. I'll leave it there. Thanks very much.
Thank you, Luke. Thank you both for great introductions. I'd like to ask Claire, it's sort of in response to what you both said, but it's a kind of reaction also to what Luke has said. You've made the point very, very clearly with lots of detail about how we've led up to here historically, and also that while you recognise that perhaps it has not been used to protect rights, particularly in the last 2 years, it shouldn't be allowed to just be changed and go through, and actually it should be reformed somehow. How would you, I mean, bearing in mind what Luke said, whether you agree with it or not, and I'd like to hear that, but what would be your suggestion for what should happen with this? And I know it's a really weighty document, but what's the most egregious thing that you think should be argued for and challenged within all of this, and the impact it might have on us? Or do you, or you might just say, well, actually, I think we could get rid of it if we could have something better. But what, Claire, what do you think?
So just to go back, obviously, to what Luke said, and in some ways, I do agree with him, because I think we're both coming from the premise that the current system, in the form it is, hasn't done anything to deal with the egregious overreach and the breaches that have occurred, especially in the last 2 years. So I do recognise that. Luke is mentioning about strengthening rights through the political mechanism, limiting what, the ability that courts have to impact upon our rights. He's talking about the political sphere being used to strengthen them. But my concern is that I think we have to have an honest conversation about whether the political system at the moment can be trusted to do that. That's part of the problem that I think that we've got. So where I'm coming from is that I don't think that we should do nothing about the reforms, because I do have some quite serious concerns about permission stages and not being able to challenge secondary legislation. What I'm not saying is that we've got a perfect system that we don't need to then say ourselves we need to have some reforms over. What I think the biggest problem that we're facing at the moment is that we absolutely seem to have the judiciary that make political decisions according to the time and the narrative. We all know that judges, some judges are political appointments. We have the parliamentary system that doesn't seem to be working, and I would encourage everybody to go and have a look at the 1 year review of the Coronavirus Act, which was August last year, and just have a look at how there was a complete breakdown with how Parliament was behaving, what they could and couldn't do, how ministers' hands were tied, and they talk about human rights breaches there as well. What I think that we all need to think about collectively is we need to come right back to basics and say what we've got at the moment isn't working. It's not working. But if we do nothing about what the government are saying, we could end up in a worse situation. Do we tear it all up, or do we demand that it all be torn up and we be involved in writing something which is strengthening the individual's rights against the state? And I think that's where we need to start from.
Okay, thank you. Luke, Claire says that the political system's not to be trusted. I don't want to put words in her mouth, but I'm not sure if that means, because I know that in conversations I've had with Claire, she agrees that activism, as you've said, Luke, can change things. But there is a question, isn't there? Like, we've got an American Constitution that came out of political struggle. I take your point. It's all, if you're handing over more to really smart people in the judiciary, what does that mean about the public space? But is it really realistic just to allow this all to be implemented, even though it's been on a manifesto, people have been voted in? What about things, for instance, that specify that public interest can supersede individual rights. What about things like that? Should it not be the case that it should be criticised and challenged at all? Are you saying that just let this come through, and then separately just people go out and campaign? Or should there be something done with some elements of it?
Okay, so two questions. The first is there some justification to create some written document that kind of codifies the values and rights that we hold very dear? And I suppose the first question arising from that would be, well, what would you write down, and how would you trust that the legal system would interpret it in a way which you could continue to trust over time? One thing we've seen in the context of the United States is a hugely elevated role for the judiciary in a way which is no longer a secret or particularly hidden. You know, the judiciary in the United States is a key part of their political culture, and the appointment of judges is highly politicized. And I think that creates huge problems. You have very, very significant issues of public policy, of moral, political questions being decided by people who are all the same unelected, but nonetheless appointed. I don't think that's a good scenario, but it is one which arises when you write down a constitutional document, which you then seek to, which you then purport to use to protect your freedom in the future. Someone will need to use that document. That will be the courts and judges. And at that stage, the control over your democratic freedom passes outside of politics and into the hands of technocrats and the judiciary. I think that's a real danger. On your second point, this question about whether reference in the reform to prioritizing the public interest over and above individual rights, I actually think there is a point to that. I don't think that is something that should necessarily be feared. You know, it's true that individual liberty and individual rights interact with the public interest all the time, and it's ridiculous to pretend that it doesn't. You know, my individual freedom is contingent upon there being a society there to facilitate it. You know, I don't exist in a vacuum. But what I think the point that we should be critical on the reforms about is that what the reforms are talking about is allowing judges to factor in some legally defined notion of the public interest when they're making decisions about human rights law. And really, that doesn't enact the public interest at all, because the public interest, as judges see it, is the public interest that has been decided by judges in the past. Okay, so the way that public interest will come to be decided in the context of this area of law will simply be what other judges think the public interest to be. And of course, we don't want a society or a culture where judges set down what the public interest is. And of course, that makes arguing for freedom more difficult, because it means doing what Together does and your political allies do, which is lobbying to affect the view in Parliament, because it's Parliament that makes and repeals law. It's Parliament that can actually get the law out of our lives. It's Parliament that can set the limits on how much the law will intrude on our lives. So rather than worry that this reform is going to, you know, introduce some catastrophic idea of the public interest into English law, what we should be really thinking about is, well, let us decide what's in the public interest. Let's lobby for it. Let's make our voices heard in Parliament and elsewhere, and not spend so much time worrying about these relatively minimal reforms to the Human Rights Act.
Okay, thanks, Luke. Claire, I just want to ask you, leading on from this and from what you said, you said that can the system actually be used, and is it almost broken or not? And then you cited in the discussion about any judicial review and any recommendations in the consultation that they will most probably be ignored. Although we did just have the vaccine mandate situation where they had consultation. Some people will say they never intended to do it, but frankly, they've done all sorts of things, and my view is they would have carried on with it, but that's open to discussion. But we did have 90% of people challenged it, and it was a resounding challenge all round. Now, there was obviously a pragmatic question about staff and numbers as well. So I'm not naive to think it was a principle in itself. But I suppose the question to you is that what Luke's saying, how you respond to that. To what extent, when you say the system has got the problem, what about us as political actors, the public sphere, the citizens, how much impact we can have on Parliament, on society, on demanding things, versus people that are in the judiciary, judges that make rules or whatever? How do you see that?
I think it's really important that we all become involved in what affects our life. And I think certainly before the last 2 years happened, many of us, myself included, were quite lazy in that regard. We outsource stuff like that because we're all too busy earning a living. And it's clear that we need to become a lot more involved, and not leave it up to the judiciary or even those elected to make those decisions for us. So I do think that activism and lobbying have a huge part to play, but I'm not sure how far ultimately you can get with that for certain things. I know that we've had some success on the vaccine mandate for the NHS. I would argue that there would have been a staffing crisis that would have been all too apparent very quickly, because I suspect the government felt that most people would give in rather than lose their jobs, and that's not what happened. However, the campaign, especially by Together and NHS 100, was obviously commendable, and I would say did have an impact. What's interesting about what Luke said really, I think, comes back to what I've talked about with the social contract. The principles about what am I willing to give. I mean, Luke's right. Yeah, we don't exist in a vacuum, but we're all normal. Well, most of us are, normal everyday people that don't want to go out and trample all over other people because we're selfish. The social contract concept is that we will give up some of our individual rights for other freedoms and being preserved and for the benefit of all. A really silly example, for instance, is we all agree so we can get from A to B on a road that will drive at appropriate speeds and not run somebody over that's standing in the middle of it, even though it might suit an individual to break the speed limit to get somewhere at a given time. So a lot of what Luke says I see tied up in that social contract, and that is the bargain that we do have with our political system. So he is right that activism plays a role in that, but my concern is, how will those rights be recognized if they're not codified in some way? What they are today, how would that who are we going to rely on to enforce them, to uphold them? And that's why I think we ended up with the legislation that we did. I know that Luke sees it differently, but if we don't have something written down, now, I'm not saying it's written in stone and isn't a living document, but if we don't have it written down and we don't have anybody that we can rely on to enforce it within the judicial system, how is it going to work?
Okay, I'm going to come out to people in just a minute, so get ready with putting your hands up with questions. But Luke, I've got to ask this, and with what Claire's saying as well. You mentioned lots of egregious legislation that impacted 3,000 new crimes, free speech impositions. We're also seeing more of them now at the same time the government's saying it wants to have free speech, right? But what about great legislation? What about if we happen to agree with it? What about you did have really great legislation happening? Should that not be something that is promoted or argued for? Or are you saying entirely it should all happen in the public sphere, political life? And how realistic is that, all right, on a day-to-day basis?
I'm not going to put you on the spot by asking you what you think great legislation would look like or be, or give me an example. But I know I sort of get the idea. But what's interesting is that quite often great social developments come from getting rid of law rather than introducing it. So all of the advances with regards to, I was asked about this previously, and I cited the example of gay rights. all the history of gay rights is a history of getting rid of law. It's not a history of introducing a law which says we will protect gay rights. Similarly, with regards to, many of the social developments that we see throughout history, segregation in the United States, greater franchise in the United Kingdom, it's not a result of passing a great bit of legislation. It's a result of getting rid of a bad one. And so I'm not sure there is such a thing as a good piece of legislation. There are necessary pieces of legislation, but I do think it becomes problematic if you say we are going to try and enforce or protect this moment of social progress through enacting a piece of law. The reason why I think that's problematic is because it's always vulnerable to being undermined or worked around. The point about a particular political freedom is that, as I've suggested, protecting that space from the law is often far more effective than passing a law which seeks to protect and codify it. And I think history shows us that.
Okay, great. Well, so it's obviously people are going to have lots to say about all of this, and some people have got very specific questions. I see that Richard Taylor was also asking about the American Constitution, and that often comes up. Obviously, it was a very different political time historically as well. There was a kind of revolution, but good points. And we're going to go to, I've got Gary Sidley first. And then can people indicate by putting the hand up sign on if they want to speak, and we'll go through them. We're going to do it in rounds of 3 to 4 and go that way. So Gary Sidley first, please.
Good evening, everybody. I've been trying to wade through the consultation document for the last few days. I'm not a legal expert by any means, and I found it quite difficult. But one thing that has occurred to me, and I'd seek my learned friends who are legal experts, their view on this, is it seems that we're in a catch-22, in that the state has demonstrated over the last 2 years that that's the biggest threat to our human rights. So in many ways, there would be a lot of sense in adjudications about human rights being made with some independence from our state, some distance, I guess in Europe in this case. But yet, the further the distance, the less likely our state are to take any notice of them. So it's as if the sensible decisions will be taken by bodies that have some distance from our own national courts. But yet, the further the distance away from our national courts, the less likely we are to take any notice of them. Have I got that completely wrong, or is that an issue that other people can see as well?
Okay, great, thank you. So I can see a number of hands coming up. I'm going to take Francis Hoare next, and then we'll do 1 or 2 others.
Thanks, Alan. I had two points really, not really questions, but if anyone wants to come back on them. Firstly, I just think this is, although this is potentially the right time to examine this issue, this is certainly not the right way to go about it. And we have had, yes, it's right that we've had a certain amount of consultation time, but I do not think in any way that we've had the very detailed, proper consideration that we need in the public sphere that we've seen this afternoon, the kind of debates that we've seen this evening. So yes, these sort of debates is absolutely right. If you read the consultation, which in many respects is quite good, especially the introduction, it's pretty well put together document, as you can imagine, because it's obviously had a lot of contributors. The substance of the introduction to it and the way it considers the issues, not necessarily the answers that it seeks. Yes, we've had this discussion for a long time, but no, not in the public domain and not given nearly as much prominence. And now we're coming out of a time when we've just been focused entirely on one issue, wrongly in the way that it's focused only on one issue and not in the right way in the view of many of us. But nevertheless, not focusing on this. And suddenly the government puts this out there, puts out the online safety bill and other things. So we don't have enough time. And the consultation ends on the 8th of March. So the right time to do it, but not nearly enough time and not nearly in the right way. it's one or two very specific points on I'm sympathetic to a lot of what Luke said as it happens, because I was traditionally very reluctant to agree that the judges should particularly have a particular role in interpreting, not in interpreting legislation, but in deciding whether or not legislation is compatible with some kind of abstract document. I'd hoped that in the last, that 2 years ago, the courts might step up to the challenge that they had the ability to step up to through the use of the Public Health Act in an unprecedented way, clear interferences with human rights. But as Luke correctly said, they didn't in a number of the cases that we brought then and subsequently. But that said, I do think that the ability of the courts to review particularly secondary legislation that's gone through no prior scrutiny necessarily, doesn't need to go through prior scrutiny. Sometimes it does and sometimes it doesn't. If it goes through prior scrutiny, it's rudimentary in nature. It's the Parliament cannot amend the any part of secondary legislation, so it's totally inadequate. And to remove, as the consultation suggests, the government might wish to do, the possibility of the courts striking down secondary legislation that's incompatible with the Bill of Rights that it proposes is entirely wrong and would take away an important part of the judicial armoury, which is the judiciary has had for many, many years. I'm just coming to an end now, and has had for many decades and longer the ability to review whether or not Parliament, whether or not a minister is accurately within the parameters that Acts of Parliament give, given acted lawfully in imposing secondary legislation. I think it's absolutely right that when Parliament doesn't pass legislation, primary legislation, doesn't go through that elevated level of scrutiny and debate, then the courts should be able to strike that down when it doesn't strike the right balance. But of course, the problem is we give that power to the courts. The courts are only as good as they are, and they're only as brave as they can be. And I think one of the issues might be that they recognise that in the two Miller cases, they perhaps overstepped the mark, certainly I think in the second Miller case about the prorogation of Parliament. And I think that as a result, they've become much more reluctant to intervene, and particularly in the Dolan case in 2020. So sorry, that's a bit of a mini speech rather than
That's all right, thank you. I'm going to take Leah Butler-Smith, and then we're going to come back to the group, and then going to come back. I can see the other hands up and keep them coming. So there's Leah, over to you.
Hello. So I am kind of representing Keep Britain Free here, and Keep Britain Free was founded by Simon Dolan, so there's a nice little segue there. It was founded on the premise that Britain was actually a free and democratic society, and we've discovered in the last 2 years that that's actually nonsense, that we're still dictated to by whomever decides whatever is right for us. One of the things that I've noted, because I don't focus too much on the law, I leave that to Claire, and she tells me what I need to know, and Francis, is the greater good scenario. So basically, I understand that politics and Parliament and everything else is a system that's built so that we, the individuals, can collectively choose the person that's going to make the decisions that are going to help us to all live our lives perfectly and wonderfully. The greater good is something that has been used by pharmaceuticals for a number of years to try and instruct people to behave in a certain way that reduces their body autonomy. So they no longer have the freedom and the right to decide what they're allowed to do with their own body. Obviously, this is the vaccine mandate scenario and so on, but there is a huge amount of worry coming, from various directions, for example, from the World Health Organization, which is another campaign that we need to really be focusing on. But at the moment, that greater good within the Human Rights Act is a real problem for me, because it does actually suggest that what they're going to suggest to you and I and everyone else is that they can tell us what to do with our own bodies because it's for someone else's benefit, which is exactly what they've been using. That model of influence and persuasion has been used for very many years by the pharmaceutical industry for things like vaccines. And that's exactly why they chose to label this a vaccine, even though it's a gene therapy, because they knew that they could convince people to do what they wanted them to do without question. And dare they say a single word, they'll be labeled an anti-vaxxer, which had already been prepared for as something that they could use within the media. And the media is the other thing, just to quickly say, the media, if we're going to control anything, or if we're going to influence anything, we should control the media, or we should take away the control the media have over the people, because they're really what's guiding most people's behaviours and decisions over this last couple of years.
Okay, thanks, Leah. So let's go to Claire first, and then Luke. You can take any one of those 3 points or make your own one. I think the question of distance of state and sovereignty, secondary legislation, or Leah's final point. So Claire, over to you. You take yourself off mute, please.
Beg your pardon. There's not many times that people can't hear me. Sorry about that. So yeah, one of the most damaging outcomes, I think, of the proposed reforms is the ability to challenge secondary legislation. It effectively means that ministerial decisions could become untouchable. I mean, I do recognise the issue that we already had with that. Francis talked about the judicial review. I personally think that they had a good case. At the moment, you know, secondary legislation can be challenged, and if you don't understand what secondary legislation is, we can perhaps talk about that in more detail. But it doesn't go through the normal, if you like, parliamentary process as primary legislation does. And it's a really important function that our judiciary can actually strike it down. If you want to think about secondary legislation, think about Matt Hancock's raft of regulations that he got up on a Sunday night and wrote to come into effect on a Monday. In essence, the reforms seem to me to be elevating secondary legislation to the same status as primary legislation, but the former is written at the behest of a minister and it doesn't undergo parliamentary scrutiny. And that to me cannot be right, that we can't have a challenge to that. You're talking about a minister, you know, writing that regulations or secondary legislation and it not being able to be challenged by us through the mechanism of the courts. And whilst I recognise, like I said, that has been a problem in the last 2 years, because as I've said, I think the Dolan case actually had very good grounds. I think that for me, this is one of the most frightening bits, that and the permission stage that these reforms intend to introduce really make my legs wobble a little bit.
Okay, thanks, Claire. Luke? Can you take your mute off, please? Luke? There we go. Oh, no, we lost you again.
Right.
There we
I'm
go.
now unmuted, yeah?
All good.
Okay. So one question, I suppose, is how do we defend our natural rights if it's not through the judiciary? I think that's a very interesting way of framing the question, because it assumes that the judiciary defend natural rights at the moment. Of course, that's not the case. The way that the judiciary operates is to consider a sort of string of authority and precedent to see whether there is a legal justification for making a decision in a particular way. The idea that that often ends up having any reflection on our natural rights or something that has any precedent in anything before the jurisprudential decisions that they are referring to, I think is wrong. So the problem we have today is that we see the judiciary as the only way of enforcing and protecting natural rights, even though we know, any lawyer knows, that that is not what they do. They make legally sound decisions based on precedent and authority, and that is very different to upholding and defending natural rights. Does that leave a difficult question as to how, in today's context, we argue for perhaps a political defense of natural rights? Absolutely, that's the key I would argue that in an age which is swamped with human rights, it's the pressing question of our age, is how we reclaim that fight in a way which empowers people involved in politics rather than law. And it's a difficult question. It's not one that I have the answer to. But I would not say that presently the judiciary has any role in defending natural rights. And if considering the system of precedent, I think makes that perfectly clear. And also the various decisions around the pandemic have also made that clear. Focusing then on the kind of the question about mandates and bodily autonomy, and I think there is a danger that we read far too much into these proposed reforms and actually become slightly conspiratorial about them. What is being proposed here is not allowing the government to completely override bodily autonomy, because they wouldn't need the Human Rights Act reform in order to do that. They would just create an act that allowed them to do that. And that really goes back to my central point, which is these Human Rights Act reforms may look concerning, but in reality, they are, if you are becoming too concerned with these reforms, you really are fiddling while Rome burns, because the real erosions and attacks on liberty happen in legislation, happen in the actions of both at the primary and secondary level. They happen through the process of lawmaking. And if you are worried about that, if you are worried about draconian law, then the Human Rights Act will not protect you. And it's shown that since its inception. So the myth that the Human Rights Act will defend you against legislative incursions into your bodily autonomy or or any other freedom is completely for the birds.
Okay, thank you, Luke. So I've got Stephen Jackson, then Myra, and then Nigel in that order. Stephen, over to you. You can take your mute off, please.
Mute. And I even put the video on. Hold on. There we go. There we are. I should have shaved. What was I going to say? If I made a quick note here, actually. Just reading through this, reading through the consultation document, there's a few phrases which jump out, of course, and I'll back up what Leah was saying. They talk about proper balance between rights of individuals and national security and effective government, so promoting government over the individual. They talk about having little regard for the rights of wider society, that being a problem with the current situation. Well, what rights are those exactly of the wider society? Those aren't determined by anything other than politics, I'd suggest. Those aren't defined anywhere. It's just by the current political situation. They talk about recognizing responsibilities exist alongside rights. Again, it's all talking about moving in the direction of putting responsibilities, undetermined, except by politics of the time, above the rights of individuals. There's a really fascinating start to this consultation document. They go back to the history of the legislation. They talk about Magna Carta, go back all that way, but they don't mention how the European Convention on Human Rights came about. They don't mention the Nuremberg trials. The Convention on Human Rights came about as a result of those Nuremberg trials and what we learned from the Second World War and wars before it. And what we've learned from that is that it is actually the rights of the individual which preserve the rights of society, which allow democracy to flourish. The whole point of protecting human rights was to protect democracy. That was its political purpose. And I think that is the debate which is missing. It's one which Luke has alluded to, but I think from the other side to suggest, and I think Luke suggested specifically, I think you said that, we've got to have regards. We always have regards to the rights of society. You don't exist on your own. That's true to an extent, but the wider society, the rights only exist because we protect the rights of the individual. What happens is if we allow the rights of the individual to be subservient to that of a mob rule, of the politics of the time, of whomever's the popular government of the time, then that democracy is at risk. and we end up with what we've seen over the last 2 years, whereby of the individual rights, democracy has been under severe attack the last 2 years, and that is precisely because of this. It's the last 2 years the government have been shouting down our throats, or down our necks, to say that it's the wider responsibilities towards society. That's what requires you to be locked up. That's what requires you to give away your rights. That is the debate we need to have. It's fundamental to this. I agree with what Luke says in terms of if we're fiddling while Rome burns, but that's because we're not having this debate as to what's happening. And so that's the point I'd like to make. And as far as the courts and the law being separate from politics, the law doesn't exist in isolation. The law is a reflection of the current politics. The law becomes an ass rather, if it doesn't reflect the will of the people at the time. And it's moved on, it's ignored, or it's taken off the books, or the courts move on. It reflects the politics of the time. And what's happened in the last 2 years, the courts reflected the politics of the time. The judges have walked into their courtrooms wearing masks. They've allowed rules to be made for masks to be put within all the court buildings. Anyone who enters them has to put on a mask. And there was no assessment whatsoever, no consideration as to the effects that might have, whether it was good or bad for anyone in the court system. They just did it. I know that because questions were asked and the response came back to that effect. They didn't care. They just, everyone's putting on masks. The government says we do it. It's political, and we have to accept that the judges are human like the rest of us and subject to the political times, and they have to be challenged also and become part of this debate. When I go back very simply, Alan, sorry for talking so long, but we're coming back. Why were these rights brought into place in the first place? And we need to go back and see what the discussion was, what the debates have been ever since the Nuremberg trials, and why they've been so important.
Okay, thank you, Stephen. So, Myra, please.
Yeah, I have a question. I suppose in a way, my feeling has been over the past 2 years that the state has, been very kind of amiss in kind of putting the individual. It has caused a lot of harm to the individual by imposing all their draconian measures. You can see it in all sorts of ways where actually a rule that might be okay for some people actually caused harm at individual level. And I just wanted to emphasize that actually, this has not worked, not just in the UK, but it's also been a problem, for instance, in Holland, where I originally come from, where there is a constitution, but the public health side of things have managed to overrule it. Canada, we've seen the Bill of Rights that has got some safeguards in, and they were completely ignored. So I was wondering, is it possible to almost kind of start looking at this from a different perspective in terms of what would we want to have in place, or what could we put in place to really defend our individual rights, and should we be campaigning for that? So for instance, with this, I have been trying to rack my brain as to what scenario I could come up with that would justify Parliament or the state to be interfering in my life for such a length of time, for instance. So the Corona Act was every time was extended by half a year. So can we not do something that we actually kind of put these human rights, these individual rights, the rights of the individual, so in some sort of framework that it can't be misused the way it's been done? It's just, I'm trying to find a solution really, and I'm asking the question.
Very good question. Thank you for asking it, Myra. Nigel, Jacqueline, please.
Hi. So we had our Keep Britain Free fortnightly meeting yesterday, which we've been having since August 2020. And one of our members, Matthew, had been through the consultation. So where we got to was that there are like nearly 30 questions. You don't have to answer them all. There were some that were particularly important, which were 8, 9, 21 and 27, which was about permission to go through the courts, and the public interest one, which has already been mentioned. And then there's one about damages and responsibility. So I guess the thing is that I think we do believe that what we the people think matters. And so therefore we should take part in this consultation, even though, as Francis said and Claire has kind of said, we're not even sure whether we need a new thing. and maybe we would have had a better process to result in an amended thing. So I guess we should do the consultation, fill in what we can, but also somehow register this, I reject your premise, you know, why are you doing this and why haven't you done it properly?
Okay, great, thank you. I've got a little question to add on at the end of this that's really to Luke, because you made a comment that it's we're fiddling whilst Rome's burning. A lot of terms are being used, and I found that in the discussion on this as well, in the run up to this, lots of people are worried about lots of different things, and sometimes the projections of those things come onto this. But I'm also confused about things, and we had a bit of a bit of a discussion on the steering group about this as well, and it's complicated. But when you say that, and Luke, and then you say, whilst Rome burns, the difference between legislation and what we're talking about, the Human Rights Act, can you just explain at the end, add this on, what you mean by that? Because some people just think legislation is legislation, there's acts and there's bills, and it's a little confusing. So if you can just specify, that would be a request as well. Right, over to Claire first, and then Luke, please.
So do you want me to answer what you said, Alan, or just?
You could do that as well if you could. Yeah, I mean, but ask you. No, but you go through it with the other questions, because they're three point saying questions. So any reflections you've got on that, or
I just want to come back actually to the greater good point, which Leah first touched on, and then was it Stephen? Then I think then came up and said what he said, which I have to say I agree with a lot of what he said. And this whole concept of the greater good is it's one of the most frightening things. And communitarianism, who decides what the greater good is? You know, who decides whether my rights should absolutely, for instance, if it's decided that the greater good is that we should all have electric cars and not petrol cars, all of a sudden does that mean that that's got to happen because it's for the greater good of the planet? Who decides that? Who proves it? There's always a lack of evidence. There certainly has been in the last 2 years, and it kind of ties in when you look back over the last 2 years and you look back at human rights in that context. We were told, don't forget, at the beginning of all of this, that when we locked down, it was to actually, aside from protect the NHS, it was to help protect a very small population, being the elderly and vulnerable, and mostly those in care. So that's a greater good concept. We were all going to have to suffer, you know, kids, teenagers, 20s, 30s, 40s, 50-year-olds, for people that were defined over a certain age and vulnerable, and in care mainly, as I've said. The fact is that when you look at that and you look at these whole greater good concepts, when you look back at that particular thing as regards locking down for the elderly, the government absolutely failed anyway, because they were not protected. You know, they were turfed out of hospitals into homes, and all of their support services were taken away. So, you know, I think this whole concept of greater good is often over bloated by those in power and those lobbying, you know, and behind them. And it's what their greater good is. It's not, you know, and often what they couch in terms of being for the greater good, actually they don't achieve. They didn't protect the elderly, as I've said, in lockdown. We all suffered as a result of it. So I do. There is some wording within the reforms about public interest, and that it's not really qualified in there what that means and how it's going to apply. And I do think there's a whole thread of public interest, greater good concepts running through a lot of legislation, bills that are on the table and concepts that are flying around at the moment with regards to how we as individuals should live our lives. And I think that in itself is something that we do need to be very aware of, and we do need to be taking action and activism over. I think Leah mentioned it with regards to, or you only have to look back at the language, don't you? I think Stephen said as well, wear a mask to protect others, not yourself. Act like you've got the virus for others, to protect them. Have a vaccine to protect others. It's this whole shift away from, and it's a political shift as well. It's a cultural shift that is trying to be embedded, that you are less important than the collective. And frankly, I'm not, that terrifies me. It really does.
Okay, thanks. Luke? Can you take your mute off?
Yeah, I'm off. So just some bland technical points. The introduction of a permission stage, well, that's not particularly unfamiliar in any other area of the law. Permission stages exist in almost every, when you bring a claim in judicial review, for example, there's a permission stage where you bring, most cases, you start with a permission stage. And it just means that the claimant is required to demonstrate that their case has some merit before it goes forward to a full hearing. Now, I know that might sound like an egregious attack on liberty, but in reality, what the Tory government is doing is just replicating stuff that exists elsewhere in the court system and applying it to human rights, which to my mind is a technical tweak, but it's not the kind of egregious assault that it's being presented as. With respect to the application to secondary legislation, it's worth remembering that the Human Rights Act has no power to get rid of any legislation. It doesn't have the power to, all it can do is make a declaration of incompatibility. So say to Parliament that this is incompatible with the Convention right and it should be thought through again. And actually declarations of incompatibility are relatively rare anyway. So the point I'm making is that the Human Rights Act has never been a good way of challenging the law, and the best way of challenging law is through pressure. And the Human Rights Act is not a very effective means of circumventing the normal democratic process. And so that's why I think it's very interesting, the point about the relationship between the individual and the public, which is where I think some of this commentary around the Human Rights Act becomes a little bit unhinged, because everyone is right to say that we need to protect the rights of the individual. But what is being talked about in the kind of Tory dog whistle way is the presentation of the Human Rights Act as something which, for example, prevents murderers from being deported out of the country, or, and what they're talking about is introducing a new consideration for a judge to take into effect when considering human rights cases. I mean, that is it. What it's not going to do, and the reason I'm saying that is this does not represent the huge incursion into individual liberty that you might think it does. It certainly doesn't when you consider it in the context of the legislative incursions that have been made over the last 2 years. I mean, really, it pales into absolute insignificance. So that's what I mean by fiddling while Rome burns. These are minor tweaks to a system of law that's existed for a very long period of time and has proven itself to be pretty incapable of defending our rights and our civil liberties when it really matters. So what we need to do is shift the conversation. And I'm not suggesting that you shouldn't respond to this consultation. By all means, make your feelings known. But this is not the kind of draconian measure that some people are talking about it in this room. It just isn't. And just to say very briefly on this issue around democracy. So we heard about, the idea that once we erode the human rights framework, or once we attack the human rights system, then democracy will be the only barrier between us and tyranny. But actually, this is the founding myth of the human rights movement. The reason why I think people place so much store in human rights law is because they worry about what might be voted for or passed if the demos are left to their own devices. So they have, and really that represents people internalizing the idea that the judiciary is the only thing keeping us from tyranny at the hands of the public. And I think that's what's at the heart of these concerns, the concerns that we've talked about tonight, the concerns that get thrown around when we talk about limiting the Human Rights Act. Fundamentally, it's a concern about the ability or willingness of the public to vote in favor of freedom-loving laws, or vote, vote against tyrannous incursions onto our freedom. And maybe that concern is justified. Maybe we have seen over the last 2 years that the public are worryingly in favor of voting in favor of ridiculous mandates and public health legislation. But that's a political problem that we need to engage with. And so just to expand on what I mean by fiddling while Rome burns, if you have a public that's massively in favor of draconian law, the Human Rights Act is not going to get in there, is not going to get in the way. What we need is to engage in that political and social problem, win the argument with people, and create a culture where rights are protected because people agree with us, not because a judge tells them to.
Okay, so we're going to come to the latter part of this conversation, and some of the comments you can see, people are saying, well, should we give too much power to MPs? Obviously, MPs are elected, and in the UK, judges are not, unlike in the States. And another one has said it's still not clear about, it was a funny one, still not clear about the actual reforms. And one of the issues is, I think if we're honest, is that we're all dealing with a lot of things that are coming down the line very quickly. Everyone has had, particularly the last 24 months, this experience of things, and we're trying to work out what's best to do and to respond to. Also, in terms of our own resources, I suppose the question is about creating a political and culture where people fight back and challenge things. It sounds like both of the speakers tonight are saying that in different ways. Clare is saying that you do need to address this legislation as well, the Human Rights Act reform. Luke's saying, well, you can do. But the question about how we actually ensure, and I think it goes to that really good question that was asked just before by Myra, what could we put in place? And I just wonder what anyone else thinks on the call about, the point that when things have changed historically, and maybe what I would call good change, when citizens and individuals impose themselves and they force that change, and that way it gets turned into legislation. It is interesting that Esther McVeigh, the MP, has suggested a freedom bill, but like some of our other conversations that we've had panels on where Francis has spoken as well, and we've discussed it, sometimes the question about how much can be done by legal experts in advance versus what we can do, that's where the tension is. So I'm really interested to hear back from anyone, rather than just posting a comment in. If you want to just ask a question or make a point before I ask the guys to come back, and I'm going to ask them to succinctly say also what their view is on not just any of the points, but on this particular piece and what you should do. We've got some new messages. But does anyone else want to speak? Hands up. I can see Richard Taylor. Over to you, Richard.
Yeah, mine's just a quick question. I can't put my video on because I'm in my pajamas, right? Mine's just a quick question on what's being proposed in this reform bill, because I know that there are pages and reams and pages, and I know this has been simplified. But from the two speakers tonight, could you tell us what the suggestions are to reforming it, and what's the wording used, and why is it a challenge?
Okay. Thank you. Any other questions before we come? So we've got a few minutes to sum up, and then we'll say a couple of things at the end. And what we can do is, that's the big question that Richard asked at the end. Obviously, Claire's already said how long the documentation is and how wide it is, but perhaps would be very useful just to summarize, if you can, but just what in particular you think is problematic with this specifically, Clare, and what from your point, I know you've shared the link and we'll share that. And we're also going to share some of the comments and links in an email to all the signatories, so you guys can decide with some reflections that we've got on it. But Clare, as well as anything else on this, some of the things you think particularly should take focus on this based on what you've been saying, a couple of minutes each, please. Over to you, Clare. Thanks.
Thank you. So there really is a lot in the consultation, and my best advice that I can give is to people to go on the British Institute of Human Rights. They literally go through every single question. They will explain that a lot better and a lot quicker than I can. And the website has already been linked in the chat. I would highly recommend that you do go on and you have a look. There's the freedom of expression, which could affect journalists. It's couched in it being a positive thing, but I don't think it is. We've got the permission stage that I do have concerns about. I know Luke doesn't see it as challenging. We've got the interpretation issues. We've got the secondary legislation challenges, and also they are looking to reform judicial reviews. I will just say that Luke, I'm sure, is aware of that, but that is a way that we challenge secondary legislation via judicial reviews at the moment, and that's also being looked at. And the conduct of people. So they're the key points I'd highlighted, but I've got loads that I've written down about them. We haven't got time, so I would direct you to the BIHR website, which is linked. And just to summarise, really, I think the problem that we've got is that every single thing now that we hear from the government, everybody has a lack of trust that what is coming out is for their benefit. And so Luke may feel that this is hysterical or we're overreacting, but I think it's justified in the context that as when you look at what has happened in the last 2 years. Secondary legislation was brought in to ram home the NHS and the Clare vaccine mandates. If we didn't have the ability to challenge that judicially as well as via activism like you did, what if the activism had failed? It would have been a last resort to go to the judiciary. Would we have won? I don't know. We should have, but would we have? I don't know. So I think what we have now is we have a complete lack of trust in the political system. What we have seen happen around the world, we've kind of seen everything swept away that we believe that we could rely on, and in lots of ways I agree with what Luke is saying. The legislation hasn't worked, it hasn't helped us, but I see it as a system failure. I do. So I think it's like a root and branch change there that we need to look at. I certainly think that we all need to become more involved, sadly, in the system of governance that we have at local level and further up, because it is only by having good people involved in those systems, incorruptible people, that we will be able to make sure that rights, human rights, enshrined rights, basic rights that we're all entitled to just by virtue of being alive, are upheld, and that we don't have this system where you've got just certain politicians railroading through very damaging policies and regulations. So overall, I've been asking myself over the last more than a year now whether the current governance and judicial systems are working and serving us properly. And my summation says, with or without these reforms, we still have that problem. Okay, so I am not saying that if we comment on these reforms and these reforms don't go ahead, that it solves the problem. It doesn't. I just feel that these reforms layer on top of that already existing problem. When you look at it in the context of the other legislation, digital identity, digital currency, which they're talking about being programmable, they all fit very nicely together to make sure that you and I really don't have any say or autonomy over our own lives anymore. So I would encourage people to get involved at all levels. I would encourage people to take part in the consultation and give their thoughts about the reforms, just to show those that are in supposed governance of us that we are interested in taking part in these debates, and we need our voices to be heard. Thank you.
Great, thanks, Claire. Thank you very much. Luke.
Luke, you're muted.
You're on mute, Luke.
I'm not anymore. So what do the reforms say? Very good question. I mean, and it is a lot of legalese. I mean, it would be difficult to whiz through them. but I think there is a real risk of their impact being massively overstated. So taking one, I'll pick up on just 2 or 3 key ones. Firstly, and most importantly, it does purport to retain all the substantive rights currently contained in the convention, but also introduce reference to common law rights which pre-existed the human rights framework, which I think is a perfectly good thing. If anything, our history of civil liberty, which preceded our human rights framework, is better. So I think that's a good thing. They say, so one issue that's been raised is providing greater clarity with regards to public interest and the roles that the court play in determining public interest. But when you look at the detail of that proposal, as I've suggested, what they're talking about there is shifting the question as to what constitutes the public interest from the judiciary to Parliament. And of course, we've learned some very serious lessons about what that means in the course of the lockdown, because Parliament created very draconian legislation. But the difference between Parliament and the judiciary is that we control the judiciary, or at least in theory, we can elect we control Parliament. We are able to elect parliaments, and that's our role as the demos. So actually, even though this looks like the government is placing greater power in their own hands to focus on the public interest, actually, when you look at the detail, what is being proposed is shifting the question as to what constitutes the public interest back into the hands of Parliament. Now, of course, that's risky because Parliament can make very draconian laws, but fundamentally, they are under our control. And that is why it's better to have that power in the hands of Parliament than it is in the hands of the judiciary. And I think that goes to the heart of what I've been arguing this evening, which is removing the Human Rights Act from our lives would be a good thing. It would place greater control in the hands of democratically elected representatives to shape our freedom. And even though that's risky, because we are always at the threat of draconian legislation, it's better to have that power in the hands of our elected representatives than it is in the hand of our judiciary.
Okay, well, firstly, I want to say thank you both to the speakers. So a little round of applause. You might be able to switch off your mute so that we can all hear that for a second if you want to do that. It's really, really great. Thank you very much, guys. That was, yeah, because of the delay, that's not looking great. Okay, but, I wanted to thank you both very much. I think what this demonstrates is that there's a lot of complex issues, and this one in particular was, being very honest and transparent. We had a big debate about it on the steering group and together, because many people, a significant amount of people, were hitting us up on social media saying, this is the next thing, we've got to do it, it's really important. And I think it's really essential that we get to have these debates out with everyone, and we really scrutinize these things and we openly discuss them, because so much has happened, particularly in the last 2 years. But, actually, if we're honest, everything from the nudge unit to when in doubt, regulate, and the imposition on the public in the last 15 to 20 years has been significant. So it's really important we have these conversations, and sometimes it may leave people somewhat undecided. And I'm not sure there's a magic wand with some of these things, but we really wanted to start this off, firstly, because the consultation is on the 8th, this series. And secondly, so that we can also lead into some of the other acts and bills and issues that are being presented to us, so we can, in the same way, really understand them and decide about what we want to do about some of which we've been challenging already, like the online safety bill and the police crime sentencing bill, and then to challenge that further in terms of campaigning, speaking to our MPs, getting that out in the press and social media, and carrying on with our work. And with issues like this, for people to decide specifically on this one, how they want to personally react to it, and also how we, as together, decides that we can respond with the consultation. So some things don't just have really nice, easy, comfortable fits. And I think it's really important. One of the things that I think has been most missing in the last 2 years is people saying, I don't know. What would have been really interesting is if the government and others perhaps had said that a bit more, rather than saying, there's the model, and by the way, there's a load of legislation that's being changed and imposed upon you. And it's all right sometimes to not be entirely clear, but we need to have lots of public debate and discussion. So I want to thank everyone, definitely thank the panelists, but thank everyone for joining today. We've got this series. The next one is on Wednesday next week at the same time, and the Wednesday after that. We've got some cracking speakers. We'll be sharing that on our social media, and keep getting in touch. And also we'll be letting you know some more calls to action as we go from here. But thank you very much for tonight. Thank you to our speakers, and thanks for joining us. And remember, we're always better and stronger together.